Hey everyone, it's Bianca Jordan, immigration lawyer at Brazen Legal, where I help immigrants get green cards every day. So, in this video, I'm going to talk about getting a green card through your parent or getting a green card through a child. Back in the day, these things used to be really easy, really simple. These cases used to have no problems whatsoever. Because when you think about it, all you're doing is showing immigration your relationship. You're basically just going to immigration and saying, hey, I'm a US citizen. I want to petition for a green card for my daughter. Or, hey, I'm a US citizen and I want to petition for a green card for my dad, and you would simply just show the relationship, which is usually through your birth certificate, and you would live happily ever after. These days, things aren't that simple anymore. So, first, let me backtrack so that I can explain who can get a green card through whom. So, if you are a US citizen and you are at least 21 years old, you can petition for your parents to get a green card. If you are a parent with a green card, then you can petition for your children and your spouse. Doesn't matter how old your children are, you can petition for them. The only caveat is that they cannot be married. If you yourself have a green card and you want to petition for your children, they cannot be married. And the reason for that is because our immigration laws don't allow for parents who have a green card to petition for married children to get a green card. But if you're a US citizen and you have married children, then you can definitely petition for them to get a green card, but not if you only have a green card. So now that we know the ground rules, let me kind of walk you through the process. If you are a parent petitioning for a child who is in the US and they came here legally and they are under the age of 21 years old and they are not married, then they can get their green card here. So you would file the complete immigration packet, the complete green card application adjustment of status packet for your child who is already in the US, and they would get their receipt notice shortly thereafter. They would get their biometrics notice shortly thereafter. And if there are no issues with their case, then the next step would be their immigration interview. And if all goes well, and depending on where you live, your child would get their green card in a couple weeks, up to a couple months, again, depending on where you live. Now, if this is a child who's in the US and they are not under the age of 21, or they are married, or they did not come to the US legally, then they would not be able to get their green card here. They would have to go back to their home country. And depending on the circumstances of their case, they might need a waiver. So that is the process for adjustment of status. If the person cannot get the green card in the US, then they are going to go through a process called consular processing. And that process entails filing Form I-130 with USCIS. And then once that application is approved, it goes to the National Visa Center. Now, if the child is in the US and they came here undocumented, or they otherwise don't qualify to get the green card here, they might need a waiver. And if that is the case, then that's a separate extra step that has to happen. You have to try to pause the case at National Visa Center while you're giving the waiver time to be processed and approved. And then once the waiver is approved and the case resumes, then once they get their interview at the embassy, they're going to the embassy with that waiver. And it's the waiver that enables them to come back to the United States once their case is approved. A common issue that I've been seeing with a lot of cases involving parents or children filing for their parent or child to get a green card is that USCIS is asking a lot of questions and wants to see a lot of evidence that there really was a parent-child relationship before the child turned 18. Because what they don't want is a situation where you have a child and then you're not in their life whatsoever. And then as soon as they turn 21, you come back and you say, hey, you're 21, I want a green card. Let's do this. They don't want that to happen. So they want to make sure that you have a genuine relationship a genuine parent-child relationship before the child turns 21. So how you prove this is by showing that the parent actually was in the child's life. If the child was under the custody of the parent, then you show documentation to that effect. If the parent was listed as the child's in case of emergency person on school records, medical records, things like that. You can use affidavits from family members. You can use work records, school records, medical records, things like that. It's just about being creative. But immigration is definitely looking for this information these days. So you want to make sure that you are providing as much evidence as possible so that you don't get your case delayed or denied. I hope you found this video helpful. Please visit brazenlegal.com to learn more about me, my law firm, and how I can help you get a green card. Thanks for watching.